How will my migration case be managed through the court?
This video is for people who want to understand how a visa-related case is managed through the Federal Circuit and Family Court of Australia, Division 2. Hi. You're about to file an application for review of a migration decision with the court. I'm going to take you through some important information. You can press pause and make notes at any time. It may be a good idea to watch this video with a support person. You can also find information on the FCFCOA website under Resources. Download the Review of a Migration Decision brochure or telephone 1300 352 000 to speak to our court staff. If you need an interpreter to help you understand, you can ask for one. You will not be charged for this service. Now, let's look at the court process in this video. Once you apply to the court, your case will follow certain steps. At the top of this screen you'll see a bar which will help guide you. Let's take a look at each step. First, you need to apply to the court.
Okay, so how do I apply to the court?
You're going to need to file a form called an application for review and an affidavit. You can find these forms on the court's website. If you don't know what an affidavit is or how to fill one out, you can find helpful information on the court website. You can also find information about free legal and social support services on the court's website by selecting Get Help. Once you complete a form, you send it to the court via a computer using e-lodgement. You'll also need to file an affidavit that includes the tribunal's decision, and you'll need to pay a fee, unless an exemption applies. There is information about fees, costs and waivers on the court website. Make sure the court always has your correct contact details so you don't miss any important information from the court. You must include your phone number, postal address, and email address. If your contact details change, you must file a new notice of address for service form and send it to the court using e-lodgement. Keeping your contact details updated is important because if you miss the notification about your hearing date and don't attend your hearing, your case may be dismissed. If you need an interpreter for your court hearing, tick this box on your application review form. You will not be charged for the interpreter. Once the court receives and checks your application form, you will be sent a file number and copies of your documents that have been officially stamped by the court. If your matter concerns a protection visa application, a different name, known as a pseudonym, will be used on court documents instead of your real name to protect your identity. Now, to let the minister know you are taking this matter to court, you need to print the stamped copies of your documents and post or deliver them to the department via the department postal address in your capital city. See the Department of Home Affairs website for office locations, or call the department on 131 881. This is what the court calls service of the document. Once the minister's lawyer receives your documents, they will send you a notice of address for service. This means the minister's lawyer has your contact information for any future communication.
Let me see if I've got this right. I have filed my application form, affidavit, and paid my application fees, and my documents have been accepted by the court. I've posted a copy of my stamped documents to the minister, and the minister's lawyer has sent me a notice of address for service. What's next?
The court will look at your application for review and the minister's response to your application, and will then make directions for your case.
What are directions?
Directions are orders from the court, outlining a timetable of actions to get your case ready for a hearing. This involves the preparation of the court book. Prepared by the minister's lawyer, this book contains all the documents held by the department or tribunal relevant to your case. Directions also outline when you must file a submission.
What is a submission?
Submissions are documents that you write to tell the judge why you think a legal error has been made in your case. The minister's lawyer will also write a submission outlining why the minister believes a legal error has not been made. Your submissions are an important opportunity to tell the judge everything you want to say about the legal error made in your case. Remember, you cannot use a submission to introduce any new evidence about whether you qualify for the visa.
How will I know when I need to attend court?
Your court date is called a hearing. Whenever you need to attend court for a hearing, the court will write to you with details of when and where or how you must attend. Your case may be heard electronically or in person. Both options are called attending court. This is a formal hearing, and everyone is expected to act respectfully. You must attend court, whether electronically or in person, whenever there is a hearing. You should arrive at least 10 to 15 minutes before your hearing time. If you do not attend court at the correct time, on the correct day, your application will most likely be dismissed, and you may be required to pay the minister's legal costs as well as your own.
What happens if I choose to withdraw my case?
You can withdraw your case by filing a form called a notice of discontinuance. There may be costs associated with withdrawing your case. However, the earlier you withdraw, the lower these costs may be. Make sure to watch Video 1, What Can the Court Do with regard to your visa review matter, and Video 3, What Do I Need to Know When I Attend Court? You can find more information about the court process on the court's website.